We certainly don't doing our asset protection work. There's a lot of cases that we've turned away that we could have made huge fees on, but they were just accidents waiting to happen. And so you have to be careful in terms of the old expression, keeping your nose clean.
Okay, let's talk about E&O coverage, or that's the way we refer to it in our industry. It's not malpractice or liability per se. It's errors and omissions.
And for a board, it's D&O, not E&O.
Okay.
Let's talk about E&O.
I understand that there are 3 carriers now that will work with individual insurance agents. In other situations, agents who...
How many did there used to be?
11.
Kind of like accounting firms.
Well, all is not lost. I might be able to obtain coverage through an insurance company because they have special arrangements with the property and casualty insurers. But the policies vary a great deal, and it's hard to unravel all that until something happens. And then you trot out the policy and say, "Whoa, I guess I'm glad I'm covered," or "I'm not covered," or "I wish I had more coverage," or maybe even less coverage.
Less coverage, sure.
Well, how do you look at that? Those policies, let's assume they're available. They pay for lawyers, as you know, or they pay for the lawyers as part of the maximum award. It's within that total, or there's separate coverage for each.
Right.
And there's more to this than lawyers. You'll have expert witnesses, perhaps. There'll be other expenses involved. It's a very confusing world to us. So how do you look at getting some kind of coverage? Is it important, number one, to have some coverage?
If it's available, and it's available at a reasonable cost, I'd say absolutely. I think that the mistake there's plenty of mistakes people make. I think one of the mistakes that people make is perhaps putting too much stock in the insurance policy or in the insurance company. Now, I kind of made a joke earlier about the 11 insurance companies being reduced to 3 and comparing them to accounting firms. And to all of our accountant friends out there, no harm intended, of course, because I don't want to get sued. That's a good business practice. In any event, the point I'm making is somebody might have coverage with an insurance company, but they do go out of business. They do pull out of states. And if somebody's putting all their stock in that insurance company for their protection, they may not be there when it comes protection time. So that's one of the points I want to make about insurance and 11 becoming 3. For whatever reason, they reduced in number. So they may not be there. They may go bankrupt. Who knows? But insurance companies aren't institutions that are guaranteed to be around forever in the particular state. Second, when I give a lecture, and usually those lectures are to professional groups, I typically ask the question, how many people in the professional group, the audience, have ever taken the time to read their malpractice policies, E&O policies, D&O, whatever policy they have? How many people have ever taken the time to read it? It's surprising. If you could have a room of 100 lawyers, and if 3 hands go up, that's a lot of hands. People just tend not to read these things. And, of course, we all do have better things to do. When do you think people finally end up looking at their policies, Dick?
When they're sued.
When they're sued. It's kind of like a partnership agreement. Nobody pays attention to it until something happens, and then it's a race to the drawer. So when people do look at their policies or have their policies analyzed, typically in the professional setting, malpractice, E&O, D&O will exclude things like acts of gross negligence or certainly intentional misconduct. And there may not be intentional misconduct, but that doesn't keep some other party, the adversary, from alleging it or a jury from finding it. So one of my professors in law school, contracts professor, actually said insurance may cover you if you fall off the roof, but you might find an exception if you happen to hit the ground. And that's the situation. You might have coverage, but you might be subject to then exceptions and exclusions in the policy so that if you had coverage, you thought you had coverage, I should say, you didn't. An example, quick example, and it's in the medical context, but a surgeon was involved in a procedure and there was an act of gross negligence on the part of one of the attending staff people. And there was an injury to the patient. Luckily not a huge injury, but there was an injury and there was a lawsuit that followed. The surgeon thought he was covered because he had a policy of malpractice. But the policy excludes acts of gross negligence. Well, he wasn't the grossly negligent party. Somebody on the attending staff was. But under the legal doctrine of respondeat superior, the grossly negligent act of the person was attributed to the surgeon. Therefore, when he had a claim for protection, since it was a grossly negligent act type of claim, there was no coverage.
I can think of a lot of examples beyond the scope of this discussion. I'm sure that the people listening can too. They're beginning to think about what might happen in their own circumstances.
If I may, Dick, and not to interrupt you, but you did ask the question or imply the question about too much or too little insurance. If I can just address that quickly, sometimes too little isn't good because you want to make sure you at least have enough in place so your insurance covers the costs of defense. Once you're sued, you've lost, as we've said together, and we've certainly acknowledged together in our discussions. And so it might be that the protection at the end of the day really is covering hundreds of thousands of dollars in legal fees. So you want at least enough to cover defense costs. On the other side, too much insurance, that might be the pot of gold that's attracting the litigants. They're not after you. They're after the insurance company and all that money under the policy. Trouble is you have to fight the battle. You have to get financially undressed in front of the other side. You have to spend hours and hours reading all this stuff that comes your way.
I know. So maybe the advice is to discuss your policy's terms and the amounts of coverage with your own personal advisor. And I assume everybody out there does have a lawyer or a confidant or someone that they talk to about these things. And to spend a little time maybe listening to, you might even listen to a partner's story, let your partner listen to yours, and come up with something that makes sense. But too little or too much is obviously, we're not going to resolve that today.
Back to that elusive balance, huh?
But that's a key area here. Now, when you really get down to it, certainly doing the right thing, having good business practices, and of course, if you are successful in this business, you are probably more of a target than if you're not successful. So as we go through the years, we build this potential up, and we need, in many cases, to have a personal financial plan. It seems to me, and I know this is your main area of interest, and where all of your experience really ends up working with your own clients. What is the bottom line best approach to keeping your assets protected from the possibility of litigation?
Well, there isn't one. And that's because this is all very case-specific, client-specific. So what's best for one person, Dick, as you can appreciate with what you do, and I know that's kind of a leading question you're asking, but what is best for one may not be best for somebody else. When it comes to clients of means that have a strong interest in protection, we in our firm very much favor going offshore for additional degrees of protection. To me, that is best in the generic sense. It doesn't necessarily mean it's best for you or anybody in this building at this particular moment or anybody on the street outside.
Okay, Barry, tell me more. I heard this story before, but I never tire of it in a way that you can. I hope I tell it the same way. Well, you do. And so when you say taking yourself offshore, man, this sounds very esoteric, complicated. I'm an insurance agent. I'm successful, let's say. My income is perhaps even several $100,000 a year, maybe more. I have a good earning potential, but I don't have control of many corporations. I don't even have a lot of other assets, but my earning power and my renewal stream of income. Why would I want to consider such a thing, and what really are you talking about here?
Well, before you would consider such a thing, you would consider other things. There's a lot of techniques that fall under the umbrella of what we refer to as asset protection, which is a component then of the larger picture integrated estate planning. Typical estate planning tends to focus on who gets what when you're dead, what are estate taxes or were they properly deferred, smooth transition of property, avoiding probate, avoiding family infighting, and so on. And these are all very important goals. But most people, I think, have the more important, perhaps selfish in a nice way, goal of let's make sure while I'm alive I can keep it. Nobody takes it from me so that my heirs do have something even to get. It's that side of the estate plan, the lifetime side of the estate plan that I'm talking about, asset protection. Asset protection is a component of integrated estate planning where we marry traditional estate planning with asset protection. Having said that then, what we're looking at are a number of techniques to accomplish asset protection goals. Asset protection really just involving something perhaps as simple, Dick, as looking at how one holds property and maybe rearranging how it's held, how title is held, so that if something should happen someday, and that's the focus here, preventative planning. I'm talking about a vaccine, not a cure, if somebody's already been bitten by the bug. something that is done before there's something that's pending or threatened against them.